I want to begin by stating what this video is not. I'm not here to win an argument or to bludgeon anyone on either side of the partisan divide. I'm here because I believe there's an issue that cuts deeper than partisanship. An issue that touches upon the very core of the American project. This video is different from my previous ones. There are no video games, there's no cultural discussion. There's only law and history. By trade, I'm a lawyer. Some of you have heard me talk at length about intellectual property law, but in truth, my primary specialty is immigration. I just happen to also think, study, and write a great deal about legal theory more broadly. I've thought long and hard about making this video on ICE, on U.S. Immigration and Customs Enforcement, because I've always wanted this channel to feel thoughtful, wholesome, and accessible. But there are times, I think, when the choice to be silent, to bury one's head in the sand, is irresponsible at best and morally wrong at worst. And given the circumstances in that respect, I think the Rubicon has finally been crossed for me. The title of this video, I understand, will unsettle some of you. Mooney, I can hear you say, are you suggesting that lawyers like yourself want to do away with immigration and customs enforcement altogether? To just open the borders, letting anyone come in without rules and laws? The answer is unequivocally no. That's not the argument, and it never has been. Lawyers have been calling for the abolition of ICE for years, not because we oppose immigration enforcement, but because ICE as an institution is extremely unusual in American law. The legal mechanisms that define it are anomalous, and those legal anomalies carry real constitutional danger. ICE is not just another law enforcement agency. It's a federal police force built on a legal foundation unlike any other in the United States. And under the wrong conditions, those foundations make ICE uniquely vulnerable to abuse. It only needs the right triggers. What follows then is my warning to anyone who will listen. If we do not abolish ICE, if we do not replace it with something less dangerous, then someday these risks will become irreversible. Maybe not today, God willing, hopefully not anytime soon, but someday, nevertheless. Let me help you understand my warning by starting at the very beginning. To understand why ICE is so dangerous, we have to go back to the very origins of America. The framers of the Constitution, our founding fathers, dreamt of a country free of the tyranny of kings and noblemen. They had just fought a war of revolution, and they together shared no greater fear than backsliding into tyranny once more. One sees again and again in their writings the fear of tyranny, with a particular concern over the powers of the executive branch, the presidency. In the Federalist Papers, number 47, James Madison, the father of the Constitution himself and our fourth president, stated to the people of the state of New York the following: "The accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, of many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." Alexander Hamilton, arguably the framer most friendly to the idea of a strong executive branch, stated in Federalist number 25 that the instruments by which the liberties of a people are destroyed are in constant progression. Power can never be safely trusted to any hands without checks. To account for the power of the executive branch, a system of checks and balances was built into the Constitution. Each branch of the government, the executive, the legislative, and the judicial, would balance the other so that no one entity or person could seize total power. Administrative seizure by a popular demagogue, perhaps, could be ostensibly halted by checks and balances and an expansion of states' rights. But there was still the threat of tyranny by force of arms. Might makes right. As James Madison said aloud in a speech to the Constitutional Convention of 1787, a standing military force with an overgrown executive will not long be safe companions to liberty. The means of defense against foreign danger have always been the instruments of tyranny. As such, the power of checks and balances was deliberately extended over the use of the armed forces. Congress is supposed to control the armed forces. It alone has the constitutional power to raise armies, fund them, and make rules governing them. The executive is meant to be the commander-in-chief, who is meant to have control only over forces lawfully raised and funded by Congress. We could spend a long time talking about how that dynamic has changed, but it's beside the point. The framers were deeply concerned about an executive branch with too much power over the military, and their fear has been deeply baked into American jurisprudence. After the Civil War, for example, Congress passed the Posse Comitatus Act of 1878, which limits the use of federal military personnel to enforce domestic law or by other government entities such as county sheriffs and justices of the peace. The act originally applied only to the Army, but it was amended in 1956 to include the Air Force, and in 2021, very early on in the Biden presidency, the National Defense Authorization Act further expanded the scope to cover the Navy, Marines, and Space Force. Why 2021 and with such urgency, I wonder? Well, who can say? In any case, policing, you will note, is conspicuously absent from the Constitution because it was never meant to be a federal power to begin with. The framers assumed that the ordinary enforcement of law, such as arrests, detentions, and the use of force against civilians, would remain local and subject to direct judicial oversight. The takeaway is, the Constitution and Congress together built a web of protections which are meant to hinder and fragment the power of the executive branch to wield force. And while those protections have not always succeeded when it comes to foreign deployments, they have largely held when it comes to the use of force domestically. But there is one area of law where the executive branch has disproportionate and virtually unchecked power to use force domestically, and that area is immigration. The Constitution vaguely vests the power of immigration with Congress. Article 1, Section 8 states that Congress has both the power to establish a uniform rule of naturalization and to regulate commerce with foreign nations. There's also the Migration or Importation Clause in Article 1, Section 9, which involves the migration or importation of people. Congress, not just in immigration but generally speaking, writes the rules. The executive branch, the president's branch, is so named because it is meant to execute what Congress delineates. Congress legislates the form, the president executes the function. From the founding of the country until the late 1800s, Congress wielded immigration policy at a macro level. Enforcement was crude but narrow, and while federal immigration officers existed, they were largely clerical and port-based. Back then, the northern and southern borders were porous, and there weren't airports yet to worry about. In fact, enforcement of immigration controls was largely state-based. This changed in 1876 when the U.S. Supreme Court declared state-level immigration laws unconstitutional, from which followed the Chinese Exclusion Act of 1882 and subsequent Supreme Court cases over its legality. In 1889, a case known as Che Chan-ping v. United States, often famously called the Chinese Exclusion Case, opened the door to a doctrine in immigration law known as plenary power, derived from the Latin plenus, meaning full power. In that case, the court described the power to exclude non-citizens as a matter of national sovereignty and foreign relations, and as such, immigration as a field of law was placed largely beyond ordinary judicial scrutiny. This was reinforced in 1893 in the holding of Feng Rieting v. United States, and then formalized in 1950 in United States ex rel. Knopf v. Shaughnessy, which ruled that the executive and legislative branches have the inherent power, plenary authority, to exclude immigrants at the threshold of entry, and that non-citizens seeking initial admission have no constitutional right to judicial review beyond what Congress provides. Quoting directly from the decision, "Whatever the procedure authorized by Congress is, it is due process as far as an alien denied entry is concerned." The only other plenary powers are war powers and foreign affairs, Indian affairs, and authority over U.S. territories, but all of these are either outwardly facing or narrow in scope. There's truly nothing like immigration law as a field where there is so much power involving so much of the population concentrated in a virtually unchecked judicial environment. But this is just the beginning, with one branch of the government having removed itself from checks and balances only to remain, and Congress, it turns out, also removes its discretion from the field of immigration. Just after the Che Chan-ping case came the Immigration Act of 1891, which shifted immigration inspection and processing from the states to the federal government. Ellis Island, the famous immigration station here in New York, opened on January 2, 1892. But the Immigration Act of 1891 did more than just shift immigration processing from state to federal jurisdiction. It also gave the executive branch explicit authority to deport immigrants who had entered unlawfully or were in excludable categories. Our modern immigration policies still use language and standards which originated from that act, by the way, including public charge and crimes of moral turpitude. In any case, the scope of immigration law was expanding rapidly, but as the scope grew, it became increasingly unwieldy for Congress to manage. By the period of the early Cold War, the federal government's immigration requirements outweighed the capacity of Congress to handle. Congress needed immigration to be flexible, quick, and most importantly, politically detached from themselves. They wanted plausible deniability, insulation from direct accountability concerning the suppression of ideology. The Internal Security Act of 1950, for example, amended the Immigration Act of 1918 by adding new grounds of exclusion to members of communist parties, language which also continues to exist to this very day. And these needs culminated in the Immigration and Nationality Act of 1952, or the McCarran-Walter Act, which specifically moved the micromanagement of immigration into the executive branch. Congress retained the power to define categories, but the executive was given more explicit power to define enforcement priorities, the timing and resource allocation, interpretation of the law itself, and the procedural details of enforcement. Which is to say, Congress began to delegate its constitutional immigration powers to the executive branch. The INA created a permanent administrative, okay, let me repeat that because it's very important, administrative immigration system. The INA cements deportation as a civil matter, immigration detention as administrative, and immigration adjudication, immigration courts as outside of Article 3, outside of the judiciary, reinforcing plenary power. Now, some immigration-related conduct is criminalized under Title 8 and Title 18, including alien smuggling, human trafficking, and illegal re-entry after removal, amongst others. When charged, those offenses are supposed to be adjudicated in Article 3 courts, with all of the protections of the criminal justice system. But in truth, the vast majority of immigration enforcement actions proceed exclusively through the civil system, even where criminal charges are legally available. That's done by choice, and it has consequences. The civil track allows the government to detain, transfer, and remove individuals while bypassing the procedural safeguards that would otherwise apply in a criminal prosecution. There's a secondary consequence, too. By choosing civil enforcement over criminal prosecution, the system sacrifices finality. Removal is fast, but it is not decisive. The same individuals may be detained, removed, and re-encountered again, and again, and again. This is only possible because immigration enforcement primarily operates outside of the criminal process. I cannot emphasize this enough. Immigration enforcement is not criminal prosecution. Immigration enforcement is administrative and civil law. When you go into 26 Federal Plaza here in New York City and you go up to the immigration courts, those are executive branch adjudicators, not Article 3 judges. If you appeal your case, it goes to the Board of Immigration Appeals or the aptly named Administrative Appeals Office, both of which fall under the purview of the U.S. Department of Justice, which is headed by the U.S. Attorney General, who reports directly to the President. In any case, after the 1952 INA, Congress only continued to delegate its power, moving immigration further and further into the nearly exclusive control of the executive branch. For example, an amendment to the INA was passed in 1965, the Hart-Celler Act, which on the one hand ended a lot of the discriminatory practices of the immigration system, most notably the national origins quota regime, but in so doing also dramatically expanded the scale and complexity of immigration without fundamentally rethinking how the system would be administrated or enforced. When the workload of a legal system expands but its machinery remains the same, the system begins to rely on larger and larger amounts of discretion just to function. It has to cut corners. What do I mean? Well, if you wanted to govern a vastly expanded immigration system by statute with, "I'm just a bill, yes, I'm only a bill," the sheer molecular complexity of the system would cause everything to grind to a halt. Any meaningful change could take years. It's like Factorio or SimCity, right? If you build layer upon layer of systems without having planned the whole thing from the start, eventually the center becomes a tangled knot that you can no longer touch without the system unraveling. In immigration law, Congress is institutionally distant from the knot at the center. The executive branch is not. So Congress increasingly points to the executive, which has been administering the system all along, and says, in effect, you deal with it. And as immigration has continued to grow, continued to become more and more complicated, discretion and thus power has steadily moved away from Congress and towards the presidency. In 1986, this momentum culminates in the IRCA, the Immigration Reform and Control Act. IRCA granted millions of undocumented immigrants lawful status, and its benefits shouldn't be forgotten amidst our conversation. But structurally, IRCA expanded the scope of immigration laws substantially yet again. IRCA created an employer sanctions regime, extending the reach of immigration law deep into the interior of the country. Immigration enforcement was no longer limited to borders or ports of entry. It now touched everyday Americans. It touched workplaces, payrolls, and everyday economic life. The system was expanded to include verification of work authorization, compliance audits, and a massively expanded enforcement bureaucracy. The knot keeps getting bigger and more tangled, Congress gets more and more distant from it, and the executive branch's influence continues to grow. This is then followed by an explosion of complexity in the Immigration Act of 1990. New legal pathways are created, employment-based visas, a diversity visa lottery, temporary protected status, etc. But underlying these expansions was Congress's full embrace of administrative governance of immigration. And from this point on, immigration policy, not just the execution but the policy, stops being shaped by congressional statutes at large and more by executive interpretation. Congress has now officially given the executive branch all the tools. And in 1996, this administrative transformation is hardened in the Illegal Immigration Reform and Immigrant Responsibility Act, or IRA-IRA. IRA-IRA dramatically broadened the grounds of deportability, introduced expedited removals, expanded mandatory detention, and continued to restrict judicial review. For the purposes of efficiency in immigration, procedural safeguards are shaved away, and we are left with an administrative, civil system that wields coercive power in the form of detention and removal without judicial oversight. Immigration enforcement after IRA-IRA is now nationwide, interior, civil, discretionary, insulated from review, and punitive in effect. At this point already, immigration is in a dangerous place as a body of law, and it functions almost completely outside of its constitutional origins. But this is just the beginning. The full executive branch takeover of immigration, even now, has yet to come. On September 11, 2001, the United States experienced terror. I would know. I'm a New Yorker, and I remember it vividly, painfully vividly. Parents pulling their kids out of school, crying and shaking, the stony silence of my own parents and teachers, the weirdly sweet chalky smell and the ashy, dusty air. And nearly 3,000 people were killed that day, not by a foreign army crossing a border, but by individuals who had entered the country lawfully, who had lived in it, and who had used our trust against us. In the immediate aftermath, the central failure identified by policymakers was not a lack of laws, but a lack of integration. Intelligence was fragmented between too many parties, and enforcement responsibilities were dispersed across dozens of agencies with overlapping jurisdictions. Immigration enforcement, border control, customs inspections, aviation security, and internal intelligence all operated in parallel instead of in concert. At the time, immigration enforcement functions were primarily housed with the Immigration and Naturalization Service, or the INS, which itself was part of the DOJ. Customs enforcement operated separately under the Treasury Department. Border Patrol, Interior Enforcement, Visa Monitoring, etc. were all spread out across various institutions. No single department had unified responsibility for preventing threats that originated not abroad, but domestically. In response to these observations, in 2002, Congress passed the Homeland Security Act, and in the following year, the Department of Homeland Security, or DHS, came into existence. It was the largest reorganization of the federal government since the creation of the Department of Defense, now the Department of War, in 1947. DHS consolidated 22 separate agencies under a single cabinet-level department. The stated goal was prevention. Detect threats earlier and eliminate bureaucratic red tape to facilitate a timely response. Immigration, you will recall, was one of the many disparate elements jammed into the DHS. And with that change, immigration escaped the boundaries of mere civil administration and became embedded into a wider national security network, alongside counterterrorism and domestic intelligence operations. This was by design, it was intentional, shaped by the fear of 9/11. And from this all emerged an enforcement apparatus that is structurally unique and uniquely problematic. An anomaly of law and policy, the consequences of which lawyers have warned about ever since its creation. When the INS was dismantled, its functions were divided up amongst 3 new agencies housed within the DHS. There was U.S. Citizenship and Immigration Services, or USCIS, which was assigned responsibility for immigration benefits and general adjudications. There was Customs and Border Patrol, or CBP, which was tasked with border and port of entry enforcement. And finally, there was Immigration and Customs Enforcement, ICE, which was created to handle interior immigration enforcement and related investigative functions. ICE formally came into existence in 2003. From the outset, it was structured as a civil enforcement agency and was not designed to catch criminals. Once again, it's a civil agency. Its legal authority derives from the Immigration and Nationality Act, and its core mission is strictly administrative: the investigation, detention, and removal of non-citizens deemed removable under federal law. It was also given nationwide domestic jurisdiction, meaning that its officers are not confined to any ports of entry or border zones. They can operate all throughout the interior of the United States with authority to investigate and arrest based on immigration status rather than criminal conduct. You see, unlike traditional law enforcement agencies, ICE primarily enforces civil law rather than criminal statutes. Although certain immigration-related conduct is criminalized, immigration enforcement typically proceeds through the civil system by design and discretion rather than criminal prosecution. As a result, most immigration violations are treated as civil matters, removal proceedings are administrative, and detention commonly occurs without the initiation of criminal charges. This is an important distinction because there are procedural safeguards that typically accompany criminal policing. There are indictments, jury trials, proof beyond a reasonable doubt, and oversight by the judiciary. These immigration violations, being civil in nature, are not subject to the same procedural safeguards, but the severity of implementation of these rules in response are not meant to be as harsh or as punitive as criminal violations. At the time of its creation, this structure was presented as practical, but immigration lawyers who could see the writing on the wall began sounding the alarm. Because what ICE represented was something completely new in American governance, a civil enforcement agency with nationwide reach, broad discretionary authority, operating outside of the criminal justice system under direct executive control. It was all of the worst fears of the framers put together, a federal, domestically oriented civil police force, not accountable to state governments, given unprecedented leeway to act by Congress and the courts under the exclusive control of the president. Let's look at an illustrative example, because it's one thing to talk about the legal theory and another to see it in practice. Let's say you're driving in New York City, and you've been pulled over for a traffic violation. This constitutes a Fourth Amendment seizure, with a scope and duration limited to the purpose of the stop. A police officer must have at least a reasonable suspicion that a traffic law has been violated, and then the officer can ask you for your license and registration to run a check and address the reason for the stop. To extend the stop beyond the time reasonably required to handle the ostensible traffic violation, the officer needs independent or reasonable suspicion of other criminal activity, such as, for example, human trafficking. If the officer wishes to search the car, the officer must meet legal requirements to do so. The officer must either get consent, have probable cause to believe the vehicle contains contraband or evidence of a crime, must perform the search incident to arrest, or has a reasonable belief that the person stopped is dangerous or may gain immediate control of firearms or weapons. The officer cannot arbitrarily detain you or hold you against your will. The detention must be justified at its inception and reasonably related in scope and duration to the reason for the stop. Once a criminal arrest occurs, the state's power becomes visible. The arrest is recorded. The charges must be articulated. The individual is placed into a system where lawyers, judges, and family can locate them. Disappearance is not a feature of the criminal process. Now let's take that same hypothetical but change only one thing. Instead of a local police officer enforcing criminal law, the encounter is initiated by Immigration and Customs Enforcement. To start, ICE has statutory authority to approach and question people about immigration status. The Immigration and Nationality Act authorizes immigration officers to interrogate any alien or person believed to be an alien as to his right to be or to remain in the United States, as set forth in 8 U.S.C. Section 1357A1. In practice, that means an ICE encounter can begin the way many police encounters begin, as questioning that is presented as voluntary. Let's say then that the ICE officer believes that you, for whatever reason, might be a non-citizen. The INA authorizes that officer then to conduct a warrantless arrest if they have, and I quote, reason to believe that the alien so arrested is in the United States in violation of any law or regulation and is likely to escape before a warrant can be obtained, as per 8 U.S.C. Section 1357A2. Courts have generally construed that reason to believe language to satisfy the Fourth Amendment's probable cause requirement for an arrest, but take note that it is probable cause of civil removability, not probable cause of a crime. The underlying violation is not criminal conduct. This is where immigration enforcement begins to diverge from the way most people imagine statutory law operates. While the INA provides formal authority, what governs is not statute in isolation, but layers upon layers of regulations, internal policies, and executive discretion, much of it opaque even to us lawyers, which as a result makes ICE decisions difficult to challenge or oppose in real time. In any case, once a person is taken into ICE custody, the legal terrain shifts again. Unlike the criminal justice system, where detention is tightly linked to charges, bail determinations, and court schedules, immigration detention operates through administrative decision-making. Detentions can be arbitrary at times, and release decisions are often made by immigration officers or administrative judges. Every single person your case touches is inside of the executive branch and operates at the discretion of the president. There is no uniform bright-line requirement that detentions be short, nor is one guaranteed an early adversarial hearing before an independent Article III judge. In practice, individuals may remain in custody for extended periods while administrative processes unfold, appeals are pending, or removal logistics are arranged. Transfers between facilities can occur without notice to family or counsel. Venue and jurisdiction can suddenly change. Access to representation can be disrupted, and all of these are not bugs but features of a system designed for administrative efficiency over everything else. From the outside, this can look like disappearance, not because the law authorizes disappearances, but because the system is not built to prevent it in the way the criminal process is. But back to our stop example. If anything goes awry during the stop, let's say a conflict escalates, firearms are drawn and deadly force is used. The ICE officer is not automatically accountable to any external independent authority outside of the executive branch because the encounter and the law governing it remain administrative rather than criminal. Taken together, this produces a system fundamentally different from ordinary law enforcement. In the criminal process, the state is forced to justify itself early, publicly, and repeatedly, and even then, abuse is not uncommon. In immigration enforcement, justification can be delayed, administratively obfuscated, or even entirely missing. You will note that none of this, so far, requires illegality. None of it requires malice. This is merely the predictable outcome when administrative efficiency is prioritized over liberty. Experience should teach us to be most on our guard, to protect liberty when the government's purposes are beneficent. Supreme Court Justice Louis Dembitz Brandeis. In the realm of political science, secret police is not a conclusively defined term. In their 2006 work, Dismantling Tyranny, Transitioning Beyond Totalitarian Regimes, Ilan Berman and Michael Waller define a secret police as political police forces tasked with targeting dissidents and political opponents to preserve the status quo and the physical integrity of the government. In the article Secret Police Organizations and State Repression from the Journal of Conflict Resolution, the authors Marius Merle and Yanis Choulis offer a slightly more detailed definition that distinguishes secret police from state security forces as a whole. A secret police is defined therein as an internal security agency that uses violent policing practices and intelligence operations against political opponents or dissidents while being autonomous from the rest of the security apparatus. Merle and Choulis continue then by offering 5 criteria necessary for an internal security agency to be classified as a secret police, taken from various sources and studies of authoritarian regimes across Europe, Asia, Africa, and Latin America. The 5 criteria are as follows. Number 1. It is a political police force, denoting that it targets political opponents and dissidents to preserve the status quo. Number 2. It is not controlled by other security agencies and answers directly to the authoritarian leadership. Number 3. The identity of its members and its operations are secret. Number 4. It is an internal security organization that specializes in political intelligence and surveillance operations. And number 5. It carries out violent policing practices such as arbitrary searches, arrests, interrogations, torture, indefinite detention, and disappearances. In essence, then, a secret police is a police force that targets political enemies to protect the regime in power, is controlled by the regime in power, has its identities and operations kept secret, spies on its own countrymen, and uses violent policing to further its goals of keeping the regime in power. A regular police force is responsive to information, has to operate within the limits of a judicial system, is publicly accountable, and cannot act with impunity outside of the bounds of criminal procedure. The criteria we've just reviewed describe an institution designed to operate offensively outside of the ordinary constraints of law, visibility, and accountability. Now, these characteristics are not typically adopted all at once. Secret police don't just appear fully formed, they emerge gradually as exceptions accumulate, discretion expands, and oversight weakens. It is only in retrospect that the full configuration becomes visible. What makes a secret police force so dangerous isn't just that they use violence, right? It's the institutional conditions under which they appear that permits them to utilize violence without governmental friction. History teaches us this lesson. Every system that has produced a secret police has done so not through a single dramatic act, but through a series of structural decisions that taken individually appeared defensible or even sensible at the time. Once those structures are in place, though, the intentions matter less than the design. The ball is already rolling down the hill. The institutions that have been created outlast the individuals that made them, and the outcome is inevitable. The Founding Fathers, the framers of the Constitution, feared most of all not the seizure of power by force, but the lawful accumulation of power assembled in the wrong configuration. The greatest threat of tyranny, as they envisioned it, was not the suspension of the rule of law, but the removal of obstacles to it. You remember the Madison quote, right? Legislative, executive, and judiciary in the same hands is the very definition of tyranny. This is why the Constitution fragments power so aggressively. Legislative power writes the rules, judicial power interprets the rules, and executive power enforces the rules. When these functions remain separate, abuse is slow to coagulate, visible before it becomes a problem, and contestable if it appears. When these powers collapse into one another, however, for the sake of efficiency, so too then does abuse become fast, opaque, and difficult to resist. Institutions rarely become instruments of repression overnight. Instead, they tend to arrive gradually, through perfectly legal steps taken in the name of efficiency, security, or necessity. Discretion expands, oversight thins, accountability shifts inwards. All the decisions that led to this point could have arrived without malice, conspiracy, or any bad intention. But the outcome is a unique organization whose limited safeguards were never designed for the power it now wields, and by the time abuse becomes visible, it is no longer a deviation from that original design, but the logical endpoint of it. By the time the abuse becomes visible, it is difficult to stop it all.
My name is Victoria Slatton. I'm an immigration attorney. I currently have a client who is a U.S. citizen who is in ICE custody. She was taken yesterday under very suspicious circumstances, in my opinion, and we have been desperately trying to get her out. We filed habeas last night that was supposed to protect her from being moved and keep her in the jurisdiction. The court actually ruled, giving us an injunction that said she was not allowed to be moved from the jurisdiction and that she was not allowed to be deported. Despite that, and despite ICE having her birth certificate that shows that she was very clearly born in Maryland, they did move her to Louisiana. That is not a good sign. That is usually a last stop before deportation. They're blatantly ignoring orders from the court. They're not allowing me access to my client, and I am at a loss, and I'm incredibly angry. It is an indisputable.
I've said in a previous video that the law is just words on paper, and that the words become meaningless if they aren't enforced. Legal scholars can cry all day about how federal officers do not automatically enjoy total immunity under U.S. law. But as you've seen, ICE is different. The branch in charge of administering responsibility says they're immune, so they are. Who exactly is watching the watchmen? Abolishing ICE doesn't mean abandoning immigration enforcement. It means abolishing an institution whose very structure is an exception in the American legal system, a structure that makes abuse not only possible but likely. The remedy does not require grand sweeping change. It doesn't require utopian reform, and it needn't sacrifice efficiency to great extent. It requires only the reestablishment of constraints that are present everywhere else in our legal system. We could insist, for example, that when force is required, it be exercised through institutions designed and trained for it, rather than collapsing administrative, policing, intelligence, and punitive roles into a single body, where officers receive less than 2 months of training. We could tether detention, loss of liberty, and removal from one's home to the criminal process, with its attendant protections, recognizing that civil administration was never meant to bear punitive weight of this magnitude. We could demand transparency, accountability, and the end of anonymous discretionary enforcement incompatible with democratic governance. None of these ideas are radical. They're older than the agency itself. ICE is relatively new. We handled immigration without them before, and we surely will after they're gone. In the making of this video, I've talked to folks on both sides of the bench. I admit my own political biases, and I understand that especially conservative folks amongst you may find immigration to be a more pressing issue than I do. Even so, whatever one's views on immigration might be, the danger posed by ICE should concern us all. My fear is that if ICE is allowed to persist in its current form, even if it is not pushed further today, it will someday be tested by circumstances less restrained, by leadership less cautious, or by fear more acute. And when that day comes, the cost could be nothing less than American democracy as we know it. I hope my fear may never come to pass. But if it should come, if a secret police really does come to America, it is the responsibility of every American to resist. Deep in my heart, I do believe we shall overcome someday. I've been your host, Mooney. I hope this video wasn't too jarring for all of you in my usual audience. If this video resonated with you, share it and use it to talk with your friends, family, and loved ones. The goal is not to defeat the other side. There is no other side. There is only unity and humanity. Thank you for tuning in then to this hopefully only special episode of Moon Channel.